founder, Dr. Hibri, and the president of the organization, long before it was sexy and popular to talk about reform, she figured out that if you want to affect change in the Middle East, if you want to affect change for gender equity in Muslim countries, you can't superimpose different cultural perceptions. You can't superimpose American values or European values on another culture. American values and European values evolve from their own cultural specificity. So as well with Muslims, the evolution from within its own culture, the internal change from within, is what is going to affect change and help towards equity towards women. And Dr. Hibri started this 15 years ago, and Karama, the organization where we're at the headquarters, is taking the perspective is we want to affect change. We want to help women, and we want to make sure there is equity. And the way to do it is within the Islamic tradition. And this is the approach that we take at this organization, is that the way we work towards reform is indigenous from within our tradition. And I'm going to identify areas today where there are problems with Islamic family law as practiced in several Middle Eastern and Islamic countries. These are the areas where our advocacy, where the reform is necessary. And I believe that there is a window of opportunity to make a difference. I'm going to address the following countries. We're going to look at Egypt. Egypt is usually the pioneer when it comes to jurisprudence in the Arab Middle East. If you look in the 20s and 30s, people who wrote the commentaries of people like Sanhuri, who wrote the Code Civil for Egypt, influenced Iraq, Jordan, UAE, and many other countries around the area. So Egypt is a very, very important country to look at their jurisprudence on the family, on divorce and custody, to get a sense of where things are going in the region. You will find, we were speaking with, I think it was with my colleague here, talking about an Egyptian judge working in Iraq. So even in many Arab countries, you'll find the judiciary has a lot of Egyptians because they have this long tradition. So it's an important country to look at. Second country to look at is Jordan. Jordan is a constitutional monarchy, technically, has some democracy, although it is a monarchy. They are still very conservative in their interpretations of Islamic family law. And it's a very good model to look at a traditional pre-reform type of a family statute. Then we're going to look at Morocco, the leading reformer country currently in family law. Very, very interesting. There are very subtle changes that were made and some comments that are in some of the clauses in the articles of the Mudawwana that really are, I believe, will act as a model for further reform in other Muslim countries. Then we're going to look at Kuwait and see how they've addressed Islamic family law and their family codes. We'll look at two Gulf countries. We're going to look at Kuwait and we're going to look at the United Arab Emirates. These are two code-driven countries. And three, we're going to look at Saudi Arabia, which is the it does not have a code. It still follows the classical treatises in the past. And we're going to look at these couple of areas. I'm going to go through each one and discuss it. I'm not going to focus a lot on how you enter into a marriage contract and the relationships between offer and acceptance and so forth. But the big picture here is, according to Islamic law, we view a marriage contract as a civil contract. Unlike under canon law as a secret or a sacred document, Muslims, similar to Jewish law, view the marriage contract as a civil contract. The dissolution of the marital relationship can take on multiple forms, and we're going to go through a couple of these areas. Under Islamic law, the husband has the unilateral, at-will right to dissolve the marital relationship without cause. So this is a classical perspective that the husband has the right to dissolve the marital relationship. To many, it's a little bit of a shock. The man can do whatever he wants. Understood. But unlike in the U.S., where there's something that we call the entire controversy doctrine, where when you're going to litigate a case, you need to bring all your claims all at the same time. under Islamic law and under Middle Eastern law, you can have all these independent cases going at the same time. So while the husband has the unilateral right to dissolve the marital relationship, there are financial consequences to that. And it does not foreclose the wife's financial rights. So this is well known on the at-will dissolution. A wife is entitled to dissolve the marital relationship as well, but not at will. She has two options. She has option one, which is to dissolve the marital relationship based on cause. So she would have to substantiate fault, particular ground, impotence, physical abuse. There could be a variety of reasons that would substantiate cause, and you would be able to dissolve the marital relationship upon an application by the wife. Now, the third way is what's called a mutual divorce, khul'a, K-H-L-U. And in a khul'a setting, it is a consensual dissolution, but requires both parties to consent. It is a wife initiating the request to dissolve the marital relationship, seeking the consent of the husband to agree. These are the three primary ways to dissolve the marital relationship, and each way has certain financial consequences. If you look under the Egyptian code, in the classical era, it was very difficult to dissolve a marital relationship based on cause, except in the Maliki school. Many of the other Islamic schools had a very difficult avenue for a woman to be able to dissolve the marital relations. They were very, very strictly construed and narrow. With the advent of the family code in the Middle East, you started to see that they have adopted the more liberal interpretation, allowing a wife to dissolve her marital relationship based on cause. And Egypt is in that area. Article 6 and 10 talk about a wife being able to petition and seeking a divorce based on cause. Why is that important? Because there are financial rights. There is there is maintenance rights, alimony rights. There are postponed dower rights. In other words, in a Muslim marriage contract, each contract would include a provision that we call mahar, M-A-H-R. And this is almost as a financial lump sum to be paid at the happening of a certain event, which usually is in the event of divorce. So there are these financial rights, and the way that you proceed to dissolve your marital relationship will impact that. With the harm, if the wife petitions to seek a dissolution based on harm, the court will appoint certain investigators, either the court or experts, who would conduct a proceeding to determine who really is at fault at the dissolution. If the wife is making an allegation that he's abusing her, if we substantiate this abuse, therefore the wife would be entitled to all the rights and privileges arising therefrom the marital relationship. If both parties are responsible, then what we're going to do, we're going to apportion the financial rights accordingly. And this has become the trend in all of the other jurisdictions, where if you're seeking a divorce based on harm, the court will conduct this proceeding to determine who's at fault and apportion the financial rights accordingly. That is the case in Jordan. Article 132 also talks about apportioning the financials based on the harm. Kuwait, Article 121, also takes the same position to apportion based on harm. UAE, Article 117 through 123, also talk about apportioning the financial rights based on harm. And the Saudi system also has somewhat of an apportionment, but not provided by statute. Now, compared to the U.S., we have a problem with fault. In the good old days, if you substantiated fault, a wife would be entitled to alimony indefinitely. If she was responsible for the dissolution, she may lose her right to alimony. Fault used to be litigated everywhere in the U.S. to impact the financial rights of the parties. Now, we've taken a position in many of the jurisdictions is that we know that divorce is very emotional, it's a nightmare, it's the worst that people are involved in, although ultimately it boils down to dollars and cents. Let's try to pull out the fault. Let's try to minimize the acrimony so people don't litigate indefinitely and fight about who's at fault at the dissolution. So many states adopted no-fault divorces. And in the states